concerning post-judgment application. So post-judgment application simply means when judgment has been given, are there some applications that can be made and entertained? The purpose of this question is based on the fact that once a judge gives judgment, the judge becomes what? Functus officio. So, are there rules that operate as an exception to the functus officio rule? That's just the question. What are those applications that the same judge can still entertain despite having been what? Functus officio. The first one is what the last speaker was talking about. It's the slip rule. It's called slip rule. S-L-I-P. Slip rule. Slip rule means errors that are not fundamental. Typographical errors, or errors that we tend to be confusing if not corrected, but they do not affect the gravamen of the judgment. Let's say, for instance, the judge having awarded the judgment sum, maybe you're claiming for 3 million, and the judge gives you 2 million naira damages. And instead of saying 2 million naira, the judge says $2 million. Maybe the judge just came back from vacation. And so you look at it, either party can apply for what? Correction. So the party in whose favor the judgment is given, if he allows it to be like that, the person will be looked upon as what? A fraudulent fellow. Because we are all ministers in the temple of justice. So it is the duty of counsel on both sides to draw the attention of the court to such slip and have the court to do what? To correct. Now, either party can make some applications known to law after judgment has been given, any of the parties. So we start from the man who has won the matter, that's the judgment creditor. The first thing a judgment creditor wants to do is to do what? Execute the judgment in his favor. But he must be mindful of the number of days. It's not like they give you judgment today, you run to start executing when your opponent will not have enough time to appeal. Because appeal is what? It's a constitutional right. I'm saying in effect is the person who has won the case will have the right to make an application that will enable him do what? Execute the judgment. Now, in executing the judgment, it depends on the form of judgment being talked about. If the judgment is declaratory, then there's nothing to execute, so you have to cast your mind back. If the judgment is executory, there's nothing to do what? Because executory, declaratory judgment, most of the times, what they do is that they give you a further right of action. But as far as you're concerned, it has given you a right. If the other party tampers with it, it becomes what? Trespass. So long as it's declaratory in nature. But if it is executed, that's when you do what? You execute it. You understand? And if you look at how you execute it, by the law, you are supposed to pursue the movables of the judgment debtor. Try to execute your judgment on the movables. It's only when the movables cannot be found that an application can be made for the movables to be attached. So we'll call it writ of attachment. So and it's still the same thing as writ of what? Fife. So you don't fife a property, an immovable property, except you first of all try to get the movables. Try to attach the car, try to attach his money through garnishing proceedings. When you don't see all those things, you now file a motion on notice. When you file a motion on notice in the affidavit, you will now have to itemize all the attempts that you have made without success before my Lord can be able to do what? Grant the application to allow you to attach what? The immovable property. In the time past, when the law was very strict, once a judgment was given, the person either satisfy the judgment requirement or does what, the person will be sent to jail. And you have cases of recalcitrant judgment debtors who is okay, no problem, send me to jail. He will be there eating government money. It's the government that will be feeding him, and he doesn't care. After the term of imprisonment, the entire thing is what? He's satisfied. Maybe he has the money somewhere, he doesn't bother. That was when the common law was harsh and had like here and there. So that was when equity had to come in to be able to fashion out some remedies, which include the writ of attachment, the writ of sequestration. Sequestration simply means if, for instance, you have some entitlement, it can be sequestrated in favor of the judgment creditor. Assuming you are the one holding my entitlement and the judgment is against me, the judgment will hit you as if you are the party in the matter until you have satisfied it, and there's nothing I can do about it. Right. So in course of time, the garnishee proceedings also came on board. Garnishee proceedings simply mean that is that an application you make for court to make an order commanding somebody in the custody of your funds, is money now, somebody in the custody of your money, not to release it to you until further directive. And that further directive will be to do what? To use it to satisfy the judgment debt. So when the first application is made ex parte, served on the bank. At times you won't even know the bank that the person banks with. You can select like 7 banks, but Abuja no longer does that now. Fine, so that all the banks, they will look at your name, check your BVN. If you have an account, they file an affidavit to say, yes, this person has an account with us. And they will disclose the amount in your account. The first one is that it comes to you requesting for you to furnish details of the judgment debtor, whether he has funds with you. You do an affidavit to that effect. If my lord looks at it and says, okay, there is money enough, my lord will now make another order, which is with what? Absolute. The first one is nisi, the second one will now be absolute. Now attaching the money, and that money will now be done what? Transferred to the judgment creditor. So these are applications the person who has won the case is entitled to do what? To apply. Now, if for instance the person has tried all he could and there is just no way to get at the judgment debtor, now again, let me finish. Now again, if the person who has won the case is unable to immediately get into possession, let's say it's a property, that person can also file an application for injunction. Maybe the time of appeal of the other party is still running. You file an application for injunction for the court to command him not to sell the property, maybe to collect the proceeds, or for the court to appoint a receiver in respect of that very property, pending when the judgment will be ripe for execution. So those are the judgments that a judgment creditor can make, the application he can make. Now the judgment debtor too can also make his own applications. Some of the applications a judgment debtor can make, one is file a motion for stay of execution of the judgment, pending the examination of his appeal. So this presupposes that he must have filed a notice of appeal, because notice of appeal itself does not operate as stay of execution. So when you file your motion, when you file your notice of appeal, you also file what? Motion for stay of execution. So when you file and serve on the other party, whatever he does is as his what? Detriment. Now, if for instance, the property has been destroyed and is about being sold, the judgment debtor can make an application for the court to do what? Set aside the execution and to stop the sale if the sale has not taken place. Because once sale takes place by auction, A third party acquires it as what? Bona fide purchaser for value without. So he can bring an application for suspension of sale and for execution to be done what? Set aside. And then he will now state his reasons. His reasons may be on the issue of jurisdiction, that this suit was contested without the process being served on him, that he was not even aware. So those are some of the applications he can file. Now, if monetary judgment has been given against a judgment debtor, and the judgment debtor feels that he has no defense, or the lawyer just advised him correctly, look, there's no need going on appeal, you spend more money. Why don't you pay this money, but ask for instrumental payment? So he can file a motion for an order permitting him to pay the judgment debt by installment. He can file an application seeking that he be allowed to pay the judgment debt by installment. See the case of Zeva. Zeva is spelled the D here is silent. D-Z-E-V-E-R. D-Z-E-V-E-R against Wepe. Against Wepe. It's reported 2024. 9 Nigerian Free Law Report. Part 1943. Page 361. A judgment debtor can also make an application for the judgment to be set aside. Then he gives his reasons. Either that the court lacked jurisdiction as at the time the judgment was entered into, or that it was a default judgment. There can also be an application for interpleader or other form of third-party proceedings. If a judgment has been delivered and an attachment is in process, let's say you borrowed a car from your friend, and unfortunately for him, the day you drove the car home was the day the bailiff from the court came and attached your friend's car because they saw you driving the car. Your friend can bring an application for what? Third-party proceedings. And then similarly to somebody in custody of any property can also make an application for interpleader proceedings. Say, my lord, I don't know between these two parties, the person who has got judgment and the one who is appealing, I don't even know who I should surrender the property to. My lord can say, I have given my judgment and Fontis official. Why don't you wait until they go to appeal? Right. But if the circumstances so warrant, my lord can also look at it and entertain the application as what? A post-judgment application.